Every day in the USA, people find themselves in court.
Case entitled State of Kansas versus Christopher Lee McIlwain. It's case number 2026 CR 63. The defendant appears from the detention center Zoom location. Joseph Favre's defense counsel, Joseph Baca for the county attorney's office in the state of Kansas. This matter is scheduled to come before the court today for an evidentiary preliminary hearing. Is the state ready to proceed?
State is ready to proceed, Your Honor.
Does the defense have any announcements to make at this time?
It's my understanding the state does not have their KBI labs back on this. And of course, we would not be waiving the requirement that those be presented. So I'm not sure if the state really is ready to proceed. I think Mr. Sweeney normally wants those back before he proceeds.
Does the state intend to proceed without lab results, Mr. Baca?
Your Honor, I apologize for not knowing at least Mr. Sweeney's methods. I do know we are prepared to proceed if the court would like to proceed today. I'm not requesting any continuance or anything because I understand it was set for hearing and everybody was made to appear today. And so we are ready to proceed and can proceed without those lab results.
Very well, Mr. Baca. So it's my understanding, Mr. Favre, that we're going to proceed today with an evidentiary hearing.
Okay. Mr. McIlwain, based on that decision and what we discussed, is it your desire to proceed with the plea like we discussed, or would you like some more time?
No, the plea is fine, sir.
We were just finishing that conversation when the room closed, Judge. Sorry. So we're ready to proceed with the plea agreement. He'll waive his right to an evidentiary hearing today.
Okay, what is this plea agreement that's being considered? Mr. Baca is aware of it, I presume?
Yes, Judge, he is. So Mr. McIlwain will be pleading guilty to the count 1, possession of methamphetamine, stable degree of dismissed remaining counts. At sentencing, Mr. Baca we believe he will be third strike. But
okay, I think you're talking about Mr. McIlwain rather than the prosecutor.
Oh, yeah, I don't know Mr. Baca's criminal history. I apologize.
Okay.
Yes, Mr. McIlwain, we believe will be third strike, Judge. The recommendation at sentencing will be that we will be filing a departure motion. The state will agree to stand silent on that departure motion. Mr. McIlwain understands that's not a guarantee that departure will be granted, but given where he is and given that he has probation he's currently on for drug treatment in Sedgwick County, he would like the opportunity to finish that drug treatment and show that he can continue his drug treatment here. So.
Very well. Now, Mr. McIlwain, your attorney has told the court that you now intend to waive your right to a preliminary hearing in your case. That's what we were scheduled for today, and instead proceed with the entry of a plea of guilty to the possession of methamphetamine charge. Is that your personal decision to go ahead and do that?
Yes, sir.
All right. I've got a number of questions I need to ask you regarding the taking of a plea of guilty. We have a number of law enforcement witnesses on this meeting. The defendant has already declared his decision to waive preliminary hearing in the case. So I can go ahead and release those law enforcement witnesses at this time. They can stay with the meeting at their choice, but they're free to leave it if they want to. So we'll proceed. Now, Mr. McIlwain, if there's any question asked of you that you do not fully understand, I will give you the opportunity to confer again with your lawyer privately at any stage. Just let the court know if you need that time to get further advice, okay?
Yes, sir.
State your full legal name for the record.
It's Christopher Lee McIlwain,
How old are you right now?
36,
What's the highest level of education that you've attained?
9th grade.
Okay. Have you ever been adjudged to be mentally ill?
No, sir.
Are you currently under the influence of alcohol or any drug?
No, sir.
Are you currently taking any type of prescription medication?
No, sir.
Are you supposed to be taking any mental health meds that you are not currently getting?
No, sir.
So do you believe that today your mind is clear and that you have a full understanding of what's going on here in court?
Yes, sir.
Do you understand the nature of the charge of possession of methamphetamine?
I do, sir.
All right. You understand that when you enter a plea of guilty, you are admitting that act in count 1 that was charged by the state?
I do.
You also understand that when you enter a plea of guilty, you give up any legal defenses that you might have had to that charge?
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Favre, and that at a trial, you can present evidence on your own behalf and subpoena your own witnesses to court?
I do.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, sir.
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described.
I do.
Are you aware that you have a right to a trial by jury and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
I do.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes.
You further understand that you may appeal your sentence after entering a plea of guilty, but generally, you may not appeal your judgment of conviction after you enter such a plea.
I do.
Now, are you aware of the possible penalties that could be imposed as a result of this guilty plea that you're attempting to make?
Yes, sir.
Let's go over those. This would be on the level 5 drug line. Do you understand that in the most favorable criminal history category of I, you could receive as little as a 10-month sentence? But in the worst criminal history category of A, you could receive up to a 42-month prison sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. As you said today, Mr. McIlwain, we do not know with absolute certainty what your criminal history is. You, better than anyone else here, would know what your own criminal record looks like. But that will be researched by the Court Services Department. And based on the outcome of their research as of the date of your sentencing, that determines where you fall along the level 5 line, and then you'll be sentenced accordingly. Do you understand that?
Yes, sir.
You also understand that if you have a person felony on your record at time of sentencing, you would be presumptive prison based on that.
Yes, sir.
Been some mention of a 3 strikes rule in this case. What do you understand that to be?
This is my 3rd drug charge.
And what implication do you believe that has?
That I could possibly be sent to prison if the downward departure is not granted by you.
All right. And you understand that any departure decision is a discretionary decision made by the court.
Yes, sir.
All right. You also understand that you could receive up to a $100,000 fine for this offense?
Yes, sir.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of your legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, sir.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, sir.
You also understand that both probationary and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, sir.
Now, you also understand that we talked about this 3 strikes rule. Kansas law has many special rules that apply to criminal sentencings. You understand that if other special rules apply to you, it could affect your eligibility for probation or otherwise affect your sentence in the same way that this 3 strikes rule does.
I do.
Now, have you had an ample opportunity to discuss fully legal matters with your attorney, Mr. Favre, before proceeding here today?
I have.
Okay, you want any more time with him privately now before we go further?
No, sir.
Are you generally satisfied with the services and advice given to you by Joseph Favre?
Yes, sir.
Now, this guilty plea that you're attempting to make, has it been based upon any threats or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, sir.
Is there anything else that you thought was part of the plea agreement that hasn't been discussed accurately on the record already?
No, sir.
You understand, Mr. McIlwain, that if there are any plea discussions or agreements between your counsel and the county attorney's office, that the court is not bound by any agreements made. The court may and shall consider them as recommendations as sentencing, but would not be bound by them. Do you understand that?
Yes, sir.
Okay. So let me ask you, how do you formally plead to the charge in count 1? Possession of methamphetamine, a level 5 drug felony.
Guilty.
Okay. If you're saying you did it, we need to talk about what happened, Mr. McIlwain. According to the state's charging document, this took place on or about February 21 of 2026. Is that when it happened?
Yes, sir.
And they say that it happened somewhere in Butler County. Where was it?
I believe it was in Augusta.
Okay. And on that, they alleged that you possessed the controlled substance of methamphetamine at that time. Did you?
Yes, sir.
Where did you possess it? In other words, where was the meth?
It was in the vehicle that I was driving.
And you knew it was there?
Yes, sir.
And you knew it was methamphetamine?
Yes, sir.
Do you have the legal right to possess methamphetamine in the state of Kansas?
No, sir.
So do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for the level 5 drug felony of possession of methamphetamine?
Yes, sir.
Mr. Baca, do you know of any legal reason why the court shouldn't accept this defendant's plea?
State knows of no legal reason, Your Honor.
Mr. Favre, are you aware of any such legal reason?
I'm not, Judge. Thank you.
All right, Mr. McIlwain, are you aware of a legal reason or any other good reason why the court shouldn't accept your plea here this afternoon?
No, sir.
Court will accept the guilty plea made by the defendant and finds that that plea is made voluntarily. Mr. McIlwain has understanding of the nature of the charge against him and the consequences of the plea, and a factual basis for the plea does exist. The court finds the defendant guilty and it judges him therefore convicted of the level 5 drug crime of possession of methamphetamine. All other counts of the information are dismissed pursuant to plea agreement. The court orders a pre-sentence report be completed to accurately determine this defendant's criminal history, and the court will set an appropriate date for sentencing. Mr. McIlwain, do you have other holds on you?
I do. I have the ones out of Sedgwick County and then the ones in Allen County.
Okay. I'm just going to let you know that I'd like to sentence you today and get this over with, but I can't do that because of the pre-sentence investigation requirement and the research of your criminal history, and that takes somewhere between 6 and 8 weeks. So we're going to set your sentencing date about 2 months out. Mr. Favre, would you take a look at your calendar for Wednesday, June 10? That would be a morning setting. June 10 at 10, I will propose.
I've got probably 10's a little bit too early, but I'm good the rest of the day if there's any other times that day.
11 o'clock?
Yep, that works.
All right. Court will set the sentencing for 11 o'clock a.m. Wednesday, June 10 by Zoom. Obviously, the defendant will be participating fully in that hearing. Wednesday, June 10, 11 o'clock a.m. for sentencing in the McIlwain case. All right, Mr. Baca, are you aware of anything further that the court needs to address regarding this defendant at this time?
State is not aware of anything further, Your Honor.
All right. Mr. Favre, anything further?
Judge, so we would make one more request to modify Mr. McIlwain's bond, and I will tell the court that Mr. McIlwain did get a bond modification last time down from $10,000 to $5,000. The issue Mr. McIlwain's having is he's C-box, and he's in a drug treatment program right now in Sedgwick County that he has a hold on, and so he's hoping to get back to restart that hold, to address the hold in Sedgwick and restart his drug treatment program. But with the holds he has, as he's already said, it's hard for him to get out and to take care of getting into a drug and alcohol treatment program that he needs. And he's expressed the desire to me to go to inpatient. Basically, he's just having a really hard time with sobriety here. And so it is a little bit unorthodox for us to allow a person pending sentencing to go to another county to address the hold, but normally we're able to work pretty well with Sedgwick County. So we would ask the court to consider giving him a lower cash or surety, even still than he already has, and hopefully he can bond out and go to Sedgwick, take care of that bond, and then be present for sentencing on June 10th, with hopefully some more ammunition for the anticipated departure motion he's going to need to file.
Didn't I hear that he also has a Cali County hold?
It's Allen County,
Allen?
but he's
Okay.
good. It's Allen, but he's going to go to Sedgwick after this. He has a hold out of Sedgwick.
What's the state's position on this request?
Well, Judge, I appreciate where he's at and appreciate his willingness to get into treatment, but I also worry for him about the temptation. If he picks up anything new, that's going to be far worse for him than just waiting and finishing this, how close we are. I know he's also going to need his PSI. I think given that he's already had a modification, worried about the temptation, I would ask the court to keep the bond as it is at this time.
Should this court lower the bond in this case and release any hold in this case, I'm not sure what's going to happen with Mr. McIlwain after that. There's some suggestion here that he'll then go to some sort of Sedgwick County case and whatever goes on there. The court's simply insecure about that, about him and his future, should he be released off of the holds in this case. The court believes that the bond set in this case is reasonable, given all of the facts and circumstances of this case. And with the complications of additional holds, the court's not inclined to modify his bond at this juncture. I regret that we have to wait 2 months. Like I said earlier, Mr. McIlwain, I wish we could have just got this case over with today, but we really can't do that. And I'm just going to leave you with the current bond requirement in this case, pending our sentencing date, which has been established during the month of June. So the request considered by the court, but denied.
Thank you, Judge.
All right. Counsel, anything further we need to address on Mr. McIlwain?
Nothing from the state. Thank you, Your Honor, and thank you to the witnesses who appeared.
All right.
No, Judge.
Mr. McIlwain, you've handled yourself well here this afternoon. And we'll see you in June, and we'll see what your situation is then at your sentencing proceeding.
Thank you, Your Honor.
Right. There's nothing further then. The McIlwain matter will currently be in recess.
The driver wanted out with a brand new plan. Begged the judge for a pass to be a better man. But with holds in 3 counties and the gavel coming down, there is no bond modification in this dusty little town. Now he is waiting until June without